Hello, everyone. This is Tom Fox back again for another episode. I'm absolutely thrilled today to have Michelle Peirce with me. Michelle is with Hinckley Allen. She's the co-chair of the White Collar and Government Enforcement Group. So, Michelle, first of all, welcome to the podcast, and thank you so much for taking the time to visit with me today.
Thank you for having me, and I'm looking forward to our discussion.
So this podcast, the genesis was she posted an article entitled 10 Core Principles Common to Internal Investigations. And although I don't think she practices in the FCPA world, I found the article absolutely instructive around thinking about internal investigations. So I asked her if she would come on and talk about it, and she said she would. But before we get there, Michelle, could I ask you a little bit about your academic and professional background? Where'd you go to law school, and tell us about your legal career?
Sure. I went to law school at Boston College Law School, undergrad at Georgetown, and then the short trajectory is clerkship, large firm, and then to a small firm, and then back to where I am now at Hinckley Allen, which I think is the just right firm.
So what's the nature of your practice currently?
Yeah, so I co-chair our government enforcement and white collar group. And so in addition to having my own caseload, I help manage and oversee others in that area. And we do some Foreign Corrupt Practices Act as a group. And in addition, I do have a civil practice.
You're also in the leadership position with the Women's Bar Foundation and Association. Could you tell us a little bit about that?
Yeah, so those are two different organizations. The Women's Bar Association has as its goal fostering women both in the legal profession and in a just society, and I've been involved with that. Right now, I'm currently involved trying to help our members, who are both male and female, through the process of applying to the bench with a goal of ensuring that the bench represents the lawyers who practice before it. The Women's Bar Foundation is more of a charitable endeavor, which is near and dear to my heart. We have a number of projects where we help indigent clients and represent them one-on-one. And so I'm on that board, and I also take cases.
Michelle, I understand that in your professional background, it includes being a special assistant district attorney. And I've never practiced on the criminal side of things. I've always been on the civil side. But I wanted to ask, how do you think that experience helped shape some of your ideas around internal investigations? Or generally, how did that experience help you when you moved over into private practice?
Well, I think it helped in private practice, I'd say, because I feel everybody should be on both sides of criminal cases at some point in a perfect world, because it's very easy to get into a mode where you only see things one way. Prosecutors who are out for blood, or defense attorneys who lose kind of track that prosecutors aren't bad. You just have to do your best for your clients. So I feel that doing a little of both is really helpful. And I think that's the case here with my prosecutorial background, balancing what is exclusively now internal investigations and white collar criminal defense.
Michelle, over the past, 5, 6, 7, 8 years, the Department of Justice has communicated to the compliance community the need for self-disclosure. And even Kenneth Polite called it the need for speed in both self-disclosure and then disclosure to the Department of Justice during an investigation. I've always thought this put an incredible amount of pressure on people like you who are brought in to do the internal investigations. And I saw that as a sort of a direct line. I was wondering if that's something that you have felt as well, that the department wants speed, but the speed is you and your team getting it right and counseling your client. So I was wondering if you could maybe talk about the general philosophy behind what the department wants and then what people like you and your team do.
That's a really good question. And I think you have definitely put your finger right on what is an incredibly difficult challenge in an internal investigation and a challenge in counseling a client. They think of you as being their guard and their watchdog, and you come in and they pay you to tell them, hey, I think you need to go tell the government all the terrible things we just found. It's a really difficult conversation, especially if it is a new client. They just came to you solely for that one piece of work, so they don't necessarily have that background with you. So that's the first thing I'd say, is that it is incredibly challenging and one of my least favorite things. Also, as you noted, the line isn't always clear. There are certain types of regulatory schemes where you have to report, there's a time frame in which to do it, period. In some ways, that as painful as that can be for a client, it's easier than when it's this balance. There's not necessarily a regulatory requirement or a contractual requirement, but if you don't do it and you don't clean it up and they get you later, it's going to be 1,000 times worse and maybe company ending. The added piece, if you don't mind, Tom, is that this area is a little different, arguably, under the current administration. There have been some policies issued in recent months that, at least on their face, and we have to see how they play out, on their face, they seem to be taking a little bit more of a company forward view to disclosure, trying to give companies more reassurance that they'll do better and perhaps avoid criminal prosecution if they self-disclose, statements about making these types of investigations a little more streamlined because of the cost. So be interesting to see how that plays out, but that's a new development.
It's interesting that you raise that, because I see that as actually perhaps even putting more pressure on people like yourself, because I say the carrot's gotten bigger, but the carrot only gets bigger based upon the facts that someone like you can develop. And with the DOJ now relying more on whistleblowers, obviously we had the SEC whistleblower program, but the clock is ticking. And it just seems to me it would be someone like me picking up the phone and calling someone like you. It wouldn't be me doing the investigation, but it would be yourself. So I see even more importance to what you and your team might do. Would that be a fair assessment?
I think that's a fair assessment. I was thinking about it from a client perspective, which is you have more hope that when someone like me comes in and does an investigation and says, I really recommend you disclose this, there's a little bit more positive things to talk about. And in the past, while there was lip service to that, you really couldn't promise the client much of anything. Like, it'll be this much better, or it'll be this much better. We have to take it on faith that it's going to be better. But I agree, it's even more time pressure on us to get the work done.
Well, maybe now that we've set up this problem of internal investigations, we can maybe go to at least one of the solutions that you've articulated. And why is it important for organizations to understand the core principles behind a successful investigation, regardless of criminal, civil, employment, or regulatory?
My broad answer to that, and then I'm sure we'll dive into specifics, is you really can't get to where you're going in any aspect of your life unless you know where you want to go. And maybe more importantly, why are you going there? There's the preliminary question, which I'm not always there for, but sometimes am with existing clients, which is, hey, do we need an internal investigation? And G, do we really have to pay outside counsel to do it, or can we do it on our own?
And then what are some of the common misconceptions you have seen when companies initiate an internal investigation? Is it basically at the triage stage where it's not that bad, we can handle it? Is it failing to follow a rigorous protocol? All of the above, none of the above?
I think one of the biggest missteps I see, or misconceptions at the beginning, is the concept of privilege, which can permeate all the way through the investigation and into the aftermath. And that is assuming that if your in-house counsel is handling an internal investigation, or you bring me in to do it for you, it's privileged. We're all set. As long as Michelle's on the email, none of these emails and none of this work will be disclosed. I think that is a common misconception that many have. Even some in-house attorneys, though, maybe in a little more nuanced sense, they may have a overly optimistic belief about this investigation remaining privileged.
And that really leads us into a deeper dive discussion of the 10 core principles. You mentioned privilege. Could we just go through them as you've laid them out, and why you think they're important and how we might be able to incorporate those going forward?
Yep, that sounds great.
After privilege, we've got knowing the investigation's purpose. And here I want to ask, one of my observations when I'm a recovering civil trial lawyer. And one of my observations when I went in-house was in-house lawyers didn't tend to know who the ultimate audience was. As a trial lawyer, I always assumed the ultimate audience was the trier of fact, whether that was an ALJ, whether it was a judge, whether it was a jury. And so I tried to think about how is this going to look to the ultimate trier of fact. But so I wanted to maybe pose that in addition to knowing the investigation's purpose.
Yeah, so your point is you always have to know your audience. I think that's the case here. And the implications of who the audience is can be really significant, both to whether the work remains privileged and how quickly it has to be done and in what format. So, to give you an example, if the I need to know pretty early on when I'm engaged to come in and do an investigation, do you have a regulatory requirement that is causing you to do this? So often you might see that in the healthcare or financial world. In the healthcare world, you might have a certain amount of time to pay back, or you have a regulation that requires you to investigate the incidents in a facility, that type of thing. If you have to do the investigation as a matter of law, more likely, not 100%, but more likely that investigation will not be privileged. And you should know that going in because it might impact how you communicate with whom you communicate, what the end product is. So that's one example. Another important example that I think is fairly common that you really want to understand at the beginning is even if it isn't required by law, is the goal of this investigation to share it with certain stakeholders. An example in a case in Massachusetts that's a seminal case here was a private school had allegations of sexual misconduct by a teacher. The school wanted the attorney to do the investigation with the intention of sharing it with the community to reassure people they had looked into it, they were taking it seriously. If your intention from the outset is that it's going to be shared, the investigation typically isn't privileged to begin with because it was never intended to be confidential. So those are some of the types of things that are really important for me to know at the outset and to think through with whomever is engaging me.
What's the role of an engagement letter to start this process, Michelle?
The engagement letter is really critical. As a starting point in most states, and certainly mine, I'm in Massachusetts, though we have offices in a number of different states, it's mandatory with rare exception in my case that you have one. So it's just an ethical responsibility. In the internal investigation context, it is critical. It's the opportunity to nail down some of the issues we've been talking about. What's the purpose? Who is the audience? Who's going to be involved? And even who is the client? Does it make sense for me to represent a company in an internal investigation? Or should I be representing, for example, as I have in some instances, the audit committee only? Some of that depends upon the organization. Some of it depends upon the nature of what's being investigated. But you need that clear in the engagement letter. A critical piece, and you'll see I come back to privilege again and again because it's so central to what I do. In the engagement letter, oftentimes because people are in a hurry, they just want to get it in place, it's an urgent situation, they don't make clear that the investigation is being performed and the attorney retained to provide legal advice. There have been a number of recent cases where because the letter just said they were going to investigate the facts or look into X, Y, or Z, the court concluded ultimately that it wasn't a privileged investigation because the lawyer was doing what anyone could do, which is find facts, look into facts, rather than doing that in order to provide legal advice. So a key takeaway is if a company has a good faith belief that it's seeking legal advice, that it wants the investigation to be privileged, you better put that in the letter and some other kind of buzzwords because it'll be your burden to prove it if it's ever challenged.
Michelle, one of the debates I've heard since I've been in this field for 20 years is should you have a written report or a verbal summary? And I've done both. I've heard the arguments on both, but I really wanted to explore this with you and really what factors do you think about to help guide this decision?
Yeah, another good question, and maybe another misconception, which is I often have clients just presume I'm going to write a report. And when we talk about it and think through why and whether, we sometimes come out the other way. So, in a true attorney fashion, the answer is it depends, as you've already flagged. I know we are hated for that kind of answer, but it's true. Again, stopping at the beginning and saying, why are you retaining me? What's the goal? For example, the example I gave you about the private schools, the goal may be we need to share with the public that these were real complaints, we took them seriously. Maybe it's a public authority or some other public body. We need the world to see what we did. In that instance, you obviously need at least some kind of written report. In other instances, you might need it to satisfy a regulator by statute, by regulation, or just by experience with that regulator. It's not going to be acceptable to say we looked into it and to give them a verbal download. So some of it, to use your words, depends upon the audience. There are times, however, where I think a written report isn't necessary. If the client is simply trying to get to the bottom of, okay, we had X problem, who knew about it? Maybe you don't need it. Maybe civil litigation is on the horizon and you're going to be subpoenaed for the report. Any loose language or anything not done perfectly is going to come back to haunt you. Perhaps you keep it verbal.
What about report distribution? Does this need to be a part of the overall consideration? And how does it work into privilege or even the waiver of privilege?
Yeah, report distribution is huge. And I think an area where at times lawyers have been so embroiled in the investigation and getting the work done, and in this instance, a report, where they might not educate the recipients as carefully as they should about what to do, or more importantly, what not to do with it. You go back to the engagement letter. Who is your client? If your client is the audit committee, that report ought not be going to people who aren't your client or you risk waiver. Backing up a little bit, I really see the investigation and privilege in two big pieces. The one is it privileged to begin with? Was it for legal advice? Did you document that? The other piece that bears on your question is, did you maintain the privilege or did you waive it? And if you give the report out or someone you give it to gives it out on a not need to know basis or outside of the attorney-client relationship, you risk waiving it. Again, these issues are more and more litigated. People are diving more into these issues in subsequent civil or other litigation, and it can really come back to haunt you.
Michelle, if you're reporting to the audit committee or the full board, and the CFO says, I need to see this because I need to potentially reserve, either beyond insurance or for other reasons. And if you give it to the CFO so that they can reserve properly, is that moving us towards a potential waiver because it's not legal advice?
I think anything moves you toward a waiver because you will have a good adversary on the other side trying to say it did. That example doesn't trouble me as much because the entity or client that received the report has duties to the entity, and you can work through that. Okay, in order to function as an audit committee, as a board, our CFO needs to be able to act on what we've learned. The other piece is not everybody has to get everything. So there's certainly times where I will draft a non-privileged report that does not necessarily disclose confidential information, but offers in a more broad setting information that others who need to act on it can. So you could give that to the CFO. But in most instances, I think that the client would be able to give it to others within the broad privilege in order to protect the interests of the organization. You just have to be careful. When you give it to someone, they need to know they can't share it. If you have reason to believe you're dealing with a client with constituents who might not be good about that, firstly, you print it all over it. Throughout the investigation, you need to continue to note it's privileged if the intent is that it would be. And in some instances, we've had shown the report via a Zoom or video or some other mechanism where it isn't actually distributed by email or otherwise to make it more difficult for people to forward it.
About the Upjohn warning. As recently as last month, I attended a CLE and we talked about the Upjohn warning in the context of internal investigations. Is that something that's so ubiquitous we all understand it, or is it we think we understand something that we heard years ago, but we may be off?
I think ding ding to the second. I think it's a very difficult concept. And obviously, you're talking about the need to alert. It's called the corporate Miranda at times, which I don't love, but some people refer to it that is essentially alerting witnesses you're interviewing at a company that you represent the company, not them. It's privileged, but they don't own the privilege. It's the company's privilege. And even as you're well versed in this, but it's a very difficult thing for employees to understand when they've been brought into a conference room and their lawyers there with binders that maybe have their name on it, that to try to soak in whose privilege is it and what am I and what does this mean to me? I think even for lawyers, it can be a little tricky, but for folks hearing the Upjohn warning, I have a lot of empathy for them. It's a tough situation.
Do you help with the order and structure of an interview? Is this something that you really work on training young associates or others who may be under you? And then why is that important to the end result, to the client, this order and structure?
The order and structure of the investigation or of the interview?
For the investigation.
Okay. Definitely. I try with everything I do to bring more junior people in and to have them learn from it, do as much as they can. And I make it sound altruistic. I need other people to come in because there are a lot of documents that need to be coded and reviewed in many of these. In terms of the order, I have a default order that I think in theory for most cases is my preference. But as in any other area, you have to be nimble because that order isn't always workable. So my preferred order is preliminary interviews to understand the lay of the land. Sometimes it's a brand new client. You don't even know what they do, let alone who you need to talk to. So you need some sort of guidance about what's going on, what they think the problem is, and then maybe what you think the problem could be. My preference in this sort of default order, if I have my way, is to get documents, emails, texts, all of that first and in chronological order, because the goal is for me to understand what happened as best I can from as objective information as there is. It's not necessarily so that when I talk to a witness, I actually know more than they do. I might know their emails. I might know what others were talking about at the same time. So I like to get documents, then talk to witnesses, and then often you'll get more documents and have to go back. That preferred mechanism really has to give way to the company's need or the organization's needs and other things. So, for example, I've had situations where I've been asked to go I represented a nursing home, and I went in because there was a belief that while state auditors were looking over documents, people were actively altering documents in the building. As you can imagine, in that setting, I don't have the luxury of coffee and an interview and then let me get all my documents together. I had to make sure regulators weren't being lied to, and I had to stop that right away. So that's a really extreme example of how the order has to change. Other times where it's clear that, or you have a strong belief that person X has committed a crime, you often have to nail that down quickly before they get wind that people are being interviewed. You might need to catch them fresh. You might need to catch someone before they're terminated, and you might need to interview ahead of documents. Those are some examples.
In 2010 or 2011, when I started interviewing people like yourself who were expert in internal investigations, they to a person said the first question they would receive is, are your documents tied down? And your answer to that in many ways informed the relationship you had with the prosecutors. Because if you said yes, and it wasn't true, in the prosecutor's mind, you'd lost credibility and you might never be able to get it back. So you needed to know early on, did you have the documents tied down? Is that still true in 2025? And
it is. And it's even harder in 2025 than even 10 or 15 years ago, because the documents, when I first started practicing, we went into the building, we had the documents. We just had to figure out what drawer they were in and what room, and were any of them sitting in a truck behind the building. Awful work, but much more comforting. Now, the documents could be in someone's personal phone. It can be in a laptop that's in their attic. People use communication apps that are not sanctioned by the company, but that you have to try to get. So it is much more, it's as important, but much more difficult to ensure that you've locked down the documents. You even have now ephemeral messaging, where people have applications that they disappear either right away or in a certain amount of time. And prosecutors have been aggressive with some companies where they didn't successfully lock down ephemeral messaging. But you can imagine when you're brought into a situation, you don't know what's happening. Maybe you don't even know the client and the players. Getting to the messages that are about to blow up instantly can be difficult. So that's a very long-winded yes. It's as important and much more hair-raising than ever.
And then finally, on internal communications, why is maintaining professionalism, cool, calm, and collected, whatever you want to call it, still such an important part of being a trusted counsel?
People say it all the time, but you write like the prosecutor. Picture the scariest person in your life. Write like they're going to read it. There is a good, in terms of the client's interest in the investigation, you want everything written in a way that moves toward the goal. If one of the goals is privileged, your communications need to say attorney-client privilege whenever you send an email. They need to use words like, you've asked me for legal advice, let me provide you legal advice, and it will help button that down later. So one reason is very functional. That professional language will help you down the road. The second, the lack of professionalism, even if it's a joke, you could be up 24/7 in some of these types of investigations, and people get a little tired and goofy. That type of communication, if it is exposed, can really undermine the investigation itself. Were they objective? They're making fun of a witness. They obviously had come to a conclusion about that witness before they had completed their investigation. So it can really hurt the client. And just generally in the world, I think we all benefit from a little bit more civil and professional discourse.
And then finally, and frankly, I am so thankful you listed this, is billing. And I say that because the first partner I worked for literally beat me over the head around billing and taught me how to record time so that it would satisfy a client. But that's not the only reason around billing, because billing is work product. And you can put, I've gotten lawyers' bills and gotten attorney-client privilege waived because something was in billing. So I was wondering if you might say a few words on the importance of this, I think, completely overlooked part.
Yeah, it is overlooked, and it's something that I really stress with younger attorneys, especially if they've mainly been exposed to civil work, where you can still waive privilege, but it's a little less intense than in a criminal setting. There's a balance. We have a duty to explain the work that we're doing and in a certain level of detail, but we also have a duty to zealously protect our client and not waive. So anytime you do a billing entry, really in any case, but in particular internal investigations, white collar, you have to be very mindful of, is this confidential? I just don't write confidential information in my billing records. I try to use enough words that I'm satisfying the responsibility to let the client know what it's paying for, but not put it at risk. The added wrinkle to that, Tom, is sometimes the client, and sometimes you don't even know it, usually you do, but sometimes they're submitting your bills to insurance companies, which is even more frightening. We've had to reach arrangements where insurance companies said, we're not going to pay them because the bills are too vague, but we have to reach some compromise because I'm not going to spoon feed an insurance company the nitty gritty of some criminal issue I'm investigating. So it's a really huge issue. And also, you don't know who's processing the bills. I've had very obvious recent investigation where the CFO was a person of interest in my work. And guess who gets the bill? So much to my partner's chagrin, whose client it was, I said, we can't send any of these until I'm done. And that's what we did.
That really leads to maybe a series of questions about exploring the roles, various roles in the relationship of external counsel, such as yourself, with internal counsel. And obviously, you both have different roles moving towards the same goal. You talked a little bit early about the situation where it might be your first time to represent a client or do legal work, and maybe contrast that with a long-term client where you have a longer-term relationship with them. Could you say a few words about the roles and the relationships between those two groups?
Yeah, no, it can be a complicated relationship. So at a high level, one thing I'd say is sometimes you have to have a firm involved who has had nothing to do with the client because they need either a fully independent review or they at least are going to have to satisfy auditors that the firm doing the investigation isn't beholden to the organization because the volume of work they do. So that's at a high level something that has to be thought about when you're retaining counsel. It is a really tricky relationship at a few levels. For one, the in-house counsel has both a business role and a legal role. And so not everything that they're doing, contrary to what some of their constituents might believe, is privileged or legal work. So that can impact what they're doing. I think the other tricky part that I have, especially when it's the general counsel is new to me and I'm working with them on one of these, and hopefully I'm answering your question, is you in an internal investigation, it's more likely to be protected as privileged. It's more likely to be efficient. You have to have me directing the investigation. And you can imagine in terms of relationships, it's a little weird to come in and start bossing your client around saying, I hereby direct you to talk to this person or do that. So to me, that's one of the more awkward things, but you just have to explain it to them. Listen, I'm going to write you an email. It sounds really formal and it sounds like I'm a jerk. I'm bossing you around. But the reason is we need to make clear there's a record that I directed this because is more likely to protect it given your mixed business role. Did I answer your question?
You did, but I guess my sense wouldn't be most in-house lawyers would certainly, especially after you explained the process, understand that.
I think they do. Sometimes it can be fraught because many things that I'm brought in to look at, it has some touches on it from the general counsel who is my main contact, and that can be uncomfortable for both of us. I've had situations where my main contact, who is a general counsel, eventually couldn't be my main contact anymore. Not necessarily because they'd done anything wrong, but because from what I was learning, they were aware of whatever it is I'm looking into, and it's going to impact my investigation and the company's ability to put it forward to a regulator or to whomever if they say, why was general counsel the one guiding her when they were involved in this issue? So there are that really tricky, and so they understand it, but it doesn't make it comfortable for anyone. And it also can be really difficult. Who can I get the information from? Who can I rely on to give me what I need and to do it accurately?
Michelle, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if anyone wanted to connect with you or find out any more information about the firm or your practice, what would be the best place or places for them to go?
I think that the firm website, it's Hinckley Allen, and my email, I don't know if you will have it anywhere, but it's my last name is funny, PEIRCE @Hinckley Allen, which has a C in it. But if you Google enough of those, you should be able to pop up with my bio, and I'd be delighted to talk with you or answer questions.
Michelle, I wanted to thank you again, and I hope we can continue this conversation.
I would love to. It was a lot of fun, Tom. Thanks for having me.
Compliance Podcast Network. Start your mornings with daily compliance news, quick, sharp updates on the top compliance and ethics stories in under 5 minutes every morning in Compliance Podcast Network. Because compliance never sleeps. Need practical advice fast? Check out Compliance Tip of the Day, one actionable idea to level up your program. Short and sweet, every day on Compliance Podcast Network. Got 10 minutes? We've got the week's top 10 stories. 10 for 10 brings you the big compliance headlines. Fast, fun, and focused. Every Saturday on Compliance Podcast Network. And don't miss the Sunday Book Review, where compliance meets culture through must-read books and big ideas every Sunday in Compliance Podcast Network. Whether you're in the office, on a walk, or commuting, stay smart, stay ethical, stay tuned. Only on the Compliance Podcast Network, available wherever you listen to podcasts.